Good morning, everyone, and welcome to today's webinar. I am Chris McCauley, Director of Compliance with ProBenefits. Today's presentation is Medicare and Employee Benefits. It is meant to be a 15-minute mini webinar. To be honest, 15 minutes is pretty ambitious for this complex topic. So today's session is meant to introduce some of the issues that arise regarding Medicare and employee benefits, and then the substance of today's presentation may be used in a future presentation to further elaborate on the issues that we address here today. So with that, I want to jump right into the presentation. And before I talk about how Medicare necessarily impacts some different benefits, I first want to talk about a set of rules that regulates how employers and health plans can treat employees that are eligible for Medicare. And those rules come in the form of the Medicare secondary payer rules. These rules are not something a lot of employers are familiar with or understand. To be candid, we're not experts in all aspects of the MSP rules, but we have a general understanding of how the main components impact some of the benefits we offer. So with that, I listed here some of the main components of the Medicare secondary payer rules. First is the rules regarding coordination of benefits. The COB rules essentially detail how to treat individuals that are covered by both a group health plan and Medicare. So which one of those plans pays first in the event an employee is covered by both. And essentially what the rules say is that employers, large employers with 20 or more employees, the group health plan must pay first. So if an individual with a large employer is covered by both Medicare and the group health plan, they have a medical claim, they have to submit it first to the group health plan. The group health plan will pay or reimburse whatever is outlined by the plan, and then any remaining expenses that are unpaid by the group health plan can be submitted to Medicare for reimbursement. So for large employers with 20 or more employees, the group health plan pays first. For small employers with less than 20 employees, generally Medicare pays first, and then the group plan follows up second. The second aspect of the MSP rules is the taking into account aspect of the rules. Employers are generally prohibited from taking the Medicare status of an individual into account when offering benefits. What does that mean? Employers are not permitted to charge higher premiums to individuals that are eligible for Medicare. They're not allowed to add additional limitations to the benefits for individuals that are eligible for Medicare, and they're also not allowed to refuse to enroll individuals who are eligible for Medicare. So no taking into account the Medicare status of employees when offering benefits. Similar to the second component is the third component, which is the same benefits under the same conditions. Employers must offer the same benefits to 65 and older employees and spouses as they do to employees that are under 65. Same benefits must be offered under the same conditions. And then finally, the prohibition against incentives to drop the group health plan and enroll in Medicare. Employers are prohibited from offering 65 and older employees any incentive to decline group health coverage that would pay first. So this is, again, most of these components apply only to employers with 20 or more employees. So what does that mean in terms of incentives? Well, employers with 20 or more employees are prohibited from reimbursing Medicare premiums. Obviously, that would be an incentive to drop the group health plan and enroll in Medicare. Also, employers are prohibited from offering alternative plans to these employees. For example, an employer might offer a prescription-only plan to 65 and older employees that they don't offer to 65 and under 65 employees. What does that mean? That means that or what would that do? That that means the Medicare eligible employees might enroll in Medicare and enroll in that prescription-only standalone plan offered by the group plan. And that would be an incentive to do that rather than to enroll in the group health plan, which includes both the medical and the prescription drug component. So that's another example of an incentive that is prohibited by the MSP rules. And so with that background regarding the MSP in mind, I wanted to move forward and talk about Medicare and how it impacts some of the benefit plans. First, when we talk the rest of the time in the presentation, we're going to be talking about Medicare entitlement. What does Medicare entitlement mean? Essentially, that is eligibility for Medicare and enrollment in Medicare. So when we talk about Medicare entitlement, we're talking about someone that is actually enrolled in Medicare. So the first thing I want to talk about is how Medicare entitlement impacts Section 125 qualifying events for mid-year changes. As you know, generally once an individual elects the group health plan pre-tax at the beginning of the year, they can't make any changes mid-year. However, Medicare entitlement is a qualifying event. A participant may drop group health coverage mid-year upon Medicare entitlement. And conversely, a participant may enroll in group health coverage mid-year if Medicare entitlement is lost. Medicare entitlement generally wouldn't be lost for someone that's eligible for Medicare due to age, but it could be someone, lost for someone that is enrolled in Medicare for a reason other than due to their age. And finally, Medicare premiums for reimbursement from flexible spending accounts, premiums of any kind, reimbursement of premiums of any kind are ineligible from health FSA reimbursement. So an individual cannot pay for their Medicare premiums with FSA dollars. Moving along, there's a question as to whether employers can reimburse employees for Medicare premiums from an HRA. The technical answer is that potentially yes, certain specially designed HRAs can reimburse Medicare Part D and Part B and Part D premiums, but there are several limitations that apply that significantly limit this option. First, as we talked about, the MSP rules limit this option, so really this is only an option for employers with less than 20 employees. In addition, there are potential discrimination issues offering this particular benefit only to individuals that are 65 or older, who are often the longest tenured individuals, the highest paid individuals, so some discrimination issues apply. And there are also some additional ACA considerations which add to the conditions of offering this plan. So what's the net result of all of this is that technically HRAs can reimburse Part B and Part D premiums. However, there are significant limitations that really restrict the number of employers that can offer this option. Really, you rarely see an employer that is in the position to do that. Finally, Medicare reimbursement is permitted for retirees, so the restriction generally applies only to active employees, but Medicare premium reimbursement through an HRA is an option generally for retirees. Moving along to HSAs, health savings accounts. Individuals that are entitled to Medicare are not permitted to contribute to an HSA. So once you are enrolled in Medicare, you cannot contribute to an HSA. You may have an HSA that you contributed to before you were entitled to Medicare. You are allowed to spend down that money in the HSA even though you are entitled to Medicare. You just cannot continue contributing to the HSA. In addition, Medicare recipients can use HSA deductions to reimburse for Medicare premiums. They just cannot use the HSA money to reimburse Medicare supplemental policies. So that's Medicare and HRAs and HSAs. The last topic today is Medicare and COBRA, which is by far the most complicating and confusing issue. So I just want to touch on some of the aspects Medicare impacts COBRA. We may not be able to get in depth into all these issues, but just make you aware of them and know that these issues are out there. The first way that Medicare impacts COBRA is Medicare is potentially a reason to terminate COBRA early. So COBRA beneficiaries are generally permitted a maximum continuation period of 18 or 36 months, depending on who the beneficiary is and what the qualifying event was. However, if any of those beneficiaries that are currently enrolled in COBRA become entitled to Medicare after electing COBRA, their COBRA coverage can be terminated because of their Medicare entitlement. So if the employee elects COBRA coverage and then 6 months later they become entitled to Medicare, the employee's coverage through COBRA can be terminated. If any spouses or dependents coverage were covered under COBRA as well, the spouse or dependents coverage cannot be terminated as a result of the employee's Medicare entitlement. So that spouse and dependents coverage would continue for the regular 18 or 36-month period. Another aspect of how Medicare impacts COBRA is whether or not Medicare entitlement is a qualifying event to trigger COBRA rights. So if I'm an active employee and I become entitled to Medicare, what does that mean for COBRA purposes? We've talked about this before in our COBRA presentations, but in order for there to be a COBRA qualifying event that triggers COBRA for the individual, there must first be a triggering event and also a loss of coverage as a result of the triggering event. Medicare entitlement is in fact listed as a triggering event. However, it rarely causes a loss of coverage under the plan. What do I mean by that? Essentially, when an employee becomes entitled to Medicare, for most plans, the plan is not permitted to kick the individual off that group health plan due to the MSP rules that we have discussed previously. And even employers with less than 20 employees, most of the time their plans do not kick employees off of coverage because of their Medicare entitlement. Therefore, Medicare entitlement is rarely a qualifying event, either a first qualifying event for active employees or a second qualifying event for COBRA beneficiaries. And then finally, another aspect of this, COBRA and how it relates to Medicare, is the extension of the 18-month maximum period when Medicare entitlement happens before the qualifying event. We're going to talk about a couple examples on the next slide which really outline the ordering of events, but it's really important to know the order of events, whether Medicare entitlement happens first or whether the qualifying event and election happens first. But in this case, the third aspect here, the extension of the 18-month maximum period, when an employee becomes entitled to Medicare within 18 months prior to the termination of employment or reduction in hours, the maximum coverage period for a spouse or dependent only is extended to 36 months from the date of Medicare entitlement. So if I am an employee and I become entitled to Medicare, and then 6 months later I terminate employment, I'm eligible for COBRA. I elect COBRA for me and my spouse and dependents. Since I terminated employment, my coverage period would be 18-month maximum. The coverage period for my spouse or dependents would be 36 months from the date of Medicare entitlement. So the COBRA continuation period wouldn't be 36 months. The COBRA continuation period would just extend to 36 months beyond the date of Medicare entitlement. So as we're going to see on the next slide with some examples, it is very important to know the ordering of the events that happen. So first, let's look at an example where Medicare entitlement happens after the COBRA election. Let's say that I'm an employee and I terminate employment on January 1st of 2017. At that time, I elect COBRA for myself, my spouse, and my dependents. 6 months later, on July 1st, I become entitled to Medicare. What does that mean for my coverage and what does that mean for my spouse's coverage? and my dependents coverage. Essentially, what that means is that first, that I can be kicked off of COBRA. The MSP rules do not apply to COBRA continuation coverage, so since I became entitled to Medicare after I elected COBRA, my coverage terminates on the date that I become entitled to Medicare. That is July 1st. In addition, since my Medicare entitlement would not have caused a loss of coverage under most plans, it is not a second qualifying event for my spouse or dependent to extend COBRA coverage for an additional 18 months. Therefore, my spouse and my dependents coverage will simply continue for the regular 18-month coverage period and will not extend for an additional 18 months because my entitlement to Medicare is generally not a second qualifying event because it does not cause a loss of coverage under the plan. And what you'll see many times in this situation, especially when an active employee becomes entitled to Medicare, you'll see that they can remain on the plan, but they will voluntarily drop their plan because they are now entitled to Medicare and they no longer want to enroll in the group health plan. And in that scenario, again, there's no loss of coverage, so dropping coverage does not result in a COBRA qualifying event either for the spouse dropping Medicare coverage, the employee dropping Medicare coverage, or the employee dropping group coverage, or the spouse or dependent also losing coverage at the same time. So Medicare entitlement is generally not a first or second qualifying event. However, when Medicare entitlement happens before the qualifying event, there is this special extension period. So if I terminate employment on January 1st of 2017, however, I became entitled to Medicare last year in 2016, the maximum coverage period for the spouse or dependent extends to 36 months after Medicare entitlement. It's important to note that's not a second qualifying event. This is a special rule for Medicare entitlement that happens before the qualifying event, which extends the COBRA continuation period to 36 months after the date of Medicare entitlement, not the date of the qualifying event that leads to COBRA, but the date of Medicare entitlement. So again, I put these examples down here just to show how important it is that you understand the ordering of the events of Medicare entitlement versus the qualifying event that leads to COBRA. And so with that, that is the extent of today's substantive presentation. Again, we just wanted to address some of the issues, bring them up so that you're aware of them when they happen, know that you need to find answers to these particular situations, and perhaps in the future we'll address these issues in more detail in another presentation. Thank you for joining us today. You're, again, welcome to email any questions to Christopher@ProBenefits.com. And have a good week, and we will talk to you again in a month.